Mark Reckless, yes.
So, Mr. Starmer, you seem to be putting through, at least to me, what seems to be quite a novel proposition then, which you say that if the defence failed to put forward there's no case to answer, the judge doesn't determine there's no case to answer at the halfway stage, then it must be the case that the CPS acted properly in bringing that prosecution.
Not that it must be the case, but it is impossible to argue that there's no evidence, there's no case, because if that was the situation, it would be the duty of the judge to stop the case. So all I'm saying is that really blocks the argument. This was a case where there was no evidence. Well, the case was presented, and it was open to the judge to say if there's not the right evidence, it won't proceed. That's the only point I'm making. I'm not saying that's the test of everything. Yeah. But
Mr. Starmer, you're making a very different point then, which you said no evidence, whereas you stated before, quite correctly, that the test was sufficient evidence for a realistic prospect of conviction. Well, so whether or not the judge decides there's no evidence, how is that determinative whether sufficient evidence for a realistic prospect of conviction?
Well, it is the test for the judge is whether there's a case to answer. Now, it's not the same test whether there's a realistic prospect of conviction, but it's not far removed. The judge has the advantage of having heard the prosecution case and seen it tested. My simple proposition is that in a case where the prosecution's evidence has been heard and the judge has not removed the case from the jury, it is self-evident there's a case to answer. Now, if anybody is suggesting that in a case of serious sexual allegations, the Crown prosecution should form the view there's a case to answer, but the proceeding shouldn't be brought, then I think there's a debate to be had. It is an example of our system at work. We bring a case based on a realistic prospect of conviction. We convict on the basis of beyond reasonable doubt after the evidence has been heard.
Too much on this, but Mr. Clappison and Mr. Ellis, I want to come in.
You took some umbrage earlier when Mr. Ellis suggested Crown prosecutors might not always apply the code properly. Did your team in the North West apply the code properly initially in the Lavelle case?
Yes.
Well, how come it was then overturned following a review?
Because when you review a case, it is inevitable that you take a fresh look. There was some further evidence, and the view taken on the re-look was that there was a realistic prospect of conviction. And we've just introduced, quite rightly, a victim's right to review. This is a right of victims to ask the Crown Prosecution Service to look again at a decision. We can't run that regime on the assumption that if on an honest and open review a different decision is taken, it necessarily means the first decision was wrong.
So with a victim right to review, is there also a celebrity requirement to review?
No. It's a victim.
So why in this case was the decision taken to overturn the review and then overturn that decision for Michael Lavelle?
The scheme that is now in place was put in place in June of this year. That is a right of review. That means a victim whose case is not being proceeded with has a right to ask the CPS to review the decision and doesn't have to put a reason on the table or go through any formal procedure. We will then review the decision. We've been doing that for 3 or 4 months now. Before that, which would be this case...
I was really asking about that point. How many decisions do you get which aren't reviewed when it's just an ordinary member of the public who may not be in the public eye, yet when, in this case, when a decision was taken not to prosecute in the North West, it was reviewed and overturned in a celebrity case?
This arose because a complaint was made, and that complaint procedure has been running for years.
Is it not the case that complaints are more likely in celebrity than non-celebrity cases?
No, there's lots of complaints about all sorts of cases.
Mr. Starmer, were I concerned that you had acted criminally in the course of your office, should I take that to the police or leave it to the Bar Standards Board?
You should take it to the police.
So why in the recent case, in terms of gender-selective abortion, was the fact that there was a professional regulator, in that case a GMC, a reason for not prosecuting a case where you had a reasonable prospect of conviction?
I agreed last week that we would put a more detailed set of reasons into the public domain setting that out, which I intend to do in the very near future. My strong preference would be to put that out in detail before dealing with it piecemeal.
Well, perhaps you can just answer me one question of principle. Do you think it is in the public interest to deter gender-selective abortion?
Well, I mean, that's a very general question. In this,
Can you answer?
In this particular case, one has to bear in mind that the legislation does not in turn specifically prohibit gender-selective termination.
So you don't want to deter it?
No, I'm not. Of course, there's a public interest in upholding the criminal law, and gender-selective abortion it would be prosecuted in the right cases.
But not in this case.
Well, that's why the detailed reasoning is important, because the facts are critically important, the basis upon which the prosecution could be brought, and the detailed reasons of the public interest. And I don't want to frustrate you, but I do think that having agreed to put fuller reasons...
Well, the reason why Mr Reckless has raised it is that it was raised at Prime Minister's questions today.
Yes.
And there is a feeling that the CPS has not taken appropriate action because the policy is not clear, irrespective of the public interest. You can tell this committee today there is no question that if somebody decides to gender select, that would be unlawful. You would prosecute. Is that clear?
No.
What is the current position?
Just two or three things. What I agreed to do last week was to put detailed reasons into the public domain so that individuals could better understand our decision. I've been working on that, and I hope to do that in the very near future. That will then set out in detail what the facts of the particular case were,
right,
and why a decision was taken not to prosecute.
Leave aside that case, but because we don't know the case, and we understand you have to make decisions on the basis of the facts of each case.
Yes.
But as a matter of policy, is it unlawful for a medical professional to say, I will perform this abortion because this child is a girl?
If that's the only reason, it's unlawful.
It is. And how many cases like that have you all prosecuted?
I don't think we've had any to consider upon.
None at all, ever?
As far as I know, none. I don't think we've had to consider any other cases.
But in these cases that you have considered, you go back to the practitioner, do you? Do you investigate? Who investigates?
The police investigated.
The police investigate. So have you had any police reports on any cases? We just want to know how widespread this is.
Well, as I say, I mean, I will double-check this for the committee, but as far as I know, and certainly in the last 5 years, we have not had any of these cases investigated and passed to us to take a decision on prosecution apart from these.
That's very helpful. And when do you think this policy will come out? Because as we know, you're about to...
No, it's not a policy. It's detailed. It's a detailed reasons, and I hope to get it out in the next day or two, which is the only reason, Mr. Reckless, that I mean, it's so close to... I'm so close to be able to provide you with a much fuller answer.
Would you send us once you put it into the public domain, just in case we miss it?
Yes,
would you write to us and tell us about this? Because there is obviously great concern. But what you're telling this committee is that if anyone gender selects, you will prosecute.
If it is an offence to authorise a termination or carry out a termination, unless two medical practitioners genuinely and in good faith certify that the risk to the mental or physical health of the patient is greater by continuation than by termination. That's the test. The statute says nothing about gender or handicap or anything else.
And is that the problem?
So
should it?
Well,
because that would be
one of the things I'm going to deal with, hopefully tomorrow or the next day, but as soon as I can, is the fact that there isn't very clear guidance here. Now,
well, there isn't clear law.
But I will be. If the only reason is gender and it's got nothing to do with the risk to health, then in those circumstances it may well be an offence because the doctor would not in good faith be able to form the appropriate view. But the test is whether the doctor in good faith formed the view that set out. But
you will make this all clear.
Because I understand the concern. I understand the concern. I understand the concern. I understand the debate. It's for that reason that I think I do need to set it out in detail. And I will send it to the committee. I'll send it, Mr. Reckless, to you straight away when it's there. But I intend to deal with it and set out in clarity and detail what the position is and why the decision was taken in that particular case.
Mr. Starmer, this has nothing to do with the decision you made in this case, because the CPS judgment was there was sufficient evidence for a realistic prospect of conviction under the law. yet you determined it was not in the public interest. Why?
That is what I am going to set out in the fuller statement, so everybody can see it in the context of the facts of the particular case. I think the difficulty is that unless the full facts are there, there is concern about the decision that arrived at. And it is to answer that question that I will issue, as I say, sooner rather than later. I'm hoping.
Mr. Ellis, could you hold yourself, please? Mr. Ellis, order. Mr. Reckless is asking a question. Would you please let him ask his question?
Are you concerned that the impact of the decision you made not to prosecute in this case that there will be a greater amount of gender selective abortion, and are you proud to have that as your legacy?
I would obviously be concerned if that were a consequence. I think when the reasons are set out in detail, people will understand that that's unlikely to be the case.